I need to talk about a serious threat to this committee's oversight authority and do it just briefly. The need for Congress to have access to information in the executive branch is inherent in the Constitution. The Supreme Court has said so clearly and repeatedly. Executive branch agencies cannot limit our legislative power of inquiry merely by entering into non-disclosure agreements with one another. But that's exactly what the FBI has tried to do. Yesterday, I sent a pair of letters to the Office of Special Counsel and the FBI about the most recent example. Non-disclosure agreements are essentially gag orders, plain and simple. They thwart transparency, accountability, and seek to obstruct congressional oversight. The Office of Special Counsel, OSC for short, is a permanent independent watchdog agency, not a temporary prosecutor appointed by the Justice Department like Mr. Mueller. Following complaints from Congress, the Office of Special Counsel opened an investigation of former Director Comey. By law, one of the Office of Special Counsel's jobs is to enforce the Hatch Act. The Hatch Act makes it illegal for government officials to engage in political activity. So the Office of Special Counsel began trying to gather evidence to find out whether Comey had a political motive for his actions. But there was one problem. The FBI refused to cooperate voluntarily. OSC could have engaged in a long legal battle to force the FBI to turn over the information. But the FBI was apparently less concerned about OSC than they're concerned about Congress's oversight opportunities and responsibilities. The FBI demanded that OSC promise not to give any of the information to Congress. A gag order, that was the price of quick and easy access to the information by that agency. So OSC took the deal. But the documents and interview transcripts are vital to this committee's oversight of the FBI. We managed to obtain 2 heavily redacted witness interviews. They show that Mr. Comey had made up his mind and started drafting his controversial announcements months before the Clinton investigation was over. But we were not consulted or even informed of the FBI's insistence that OSC agree to a gag order until after the fact. According to OSC, the FBI has never asked for such a gag order before. Neither has any other agency. Why now? Why was the FBI so focused on keeping Congress in the dark? Why is it so afraid of shining the light of day on the controversial decisions Mr. Comey made in the months before he was fired? This isn't the first time the FBI has tried this trick. It also reportedly made all the agents working on the Clinton investigation agreement agree to a special gag orders. But the executive branch cannot avoid constitutional oversight by assigning agreements. This committee has oversight authority over the Department of Justice and the FBI. If there's any whiff of inappropriate partisan or political influence in these institutions under any administration or any party, this committee has a duty to get to the bottom of it. That is exactly what we will do. I expect full, complete, and timely answers to my letters. This committee needs to see the full witness interview and all the documents, including drafts and internal FBI memos about Comey's decision to make that controversial statement last summer, and I will do everything in my power to make sure that we do. Do you have anything you want to say on that subject? Because you can have whatever time you want.
Well, thank you very much, Mr. Chairman, and I'm in agreement with the general thrust of your statement. I have found that it should also apply with the sharing of intelligence with this committee, and I have sent a letter to Senator Burr. As a member of the Intelligence Committee, I have been privy to certain pieces of intelligence, as would Senator Cornyn be privy to that. It seemed to me that when I saw it, it was relevant to this committee's oversight, and yet this committee cannot receive it. So I have sent a letter which documents our rules, and hopefully the Intelligence Committee will be responsive, and that matters that involve our oversight, which, as we've discussed in the investigation, there's clear oversight of the Justice Department, and therefore matters of obstruction of justice are within the jurisdiction of this committee. And so hopefully we will be able to obtain that. I just haven't had a chance to tell you that, but I did it. Thank you.
Welcome everybody to this very important committee meeting and hearing that has very basic constitutional issues that are connected with it. We have an outstanding panel to help us go through this. So today's hearing will hear testimony related to two bills recently introduced by members of our committee. 1735, introduced by Graham, Whitehouse, and Blumenthal, as well as their members of the committee, as well as Senator Booker, who's not a member of this committee, and 1741, introduced by Senator Tillis and Coons. These bills have some things in common. Each bill attempts to codify current DOJ regulations about removals of special counsel. Each bill provides for judicial review of removal decision, and each bill has bipartisan support. It is also clear that each bill is motivated by similar concerns about the current special counsel, Robert Mueller, and his investigation into the Russian government's efforts to interfere in the presidential election. One of the bills even specifies that it applies retroactively to the date of Robert Mueller's appointment. And both bills were introduced when media speculation was rampant that President Trump was contemplating firing Mueller. The president has said that he does not intend to fire Mueller, and I think that he made the right decision. I hope that this investigation proceeds to its conclusion rapidly and stays focused on what Deputy Attorney General Rod Rosenstein charged it to investigate. The American people can be sure that this committee, which has jurisdiction over DOJ, FBI, et cetera, will take its oversight role over the investigation as seriously as I think this committee has a reputation for doing. While there is no doubt that current events are significant to the issues we discussed today, it is my hope, sincere hope, that during today's hearing, the committee will engage in a broader discussion of the grand tradition of the Senate as a deliberative body. Both of the bills we will discuss today raise potential separation of powers concerns that I believe deserve the attention of the committee and respectful discussion of it. The issues that we discuss today are bigger than the president or any of us. They concern the fundamental design of our republic. When they drafted the Constitution, founders of this nation were rightfully concerned that those in power would be tempted to abuse it to favor their own interests. To prevent this, the founders divided power among the three branches of government that I don't have to reiterate, but James Madison put it this way in Federalist 51, quote, "Ambition is made to counteract ambition." It is through, end of quote, it is through this system of checks and balances between the ambitious branches of government that our fundamental liberties are protected. There are those who argue that the rise of the modern administrative state with its federal agencies that are vested with both executive and legislative powers and even judicial powers sometimes have weakened the separation of power provisions of our Constitution, or at least changed how we should understand them. I believe that our government works best when each branch of government has a clearly defined role, and I think that even in our modern times, with our greatly expanded federal government, that is not too much for us to hope for. But it is something that we as members of Congress must carefully consider as we looked at this drafted legislation. Some who agree that these bills are good policy argue that by codifying the DOJ special counsel regulations and providing judicial review over removal removal decisions, they provide useful certainty about how disputes over the removal of a special counsel would proceed and afford the office of special counsel needed independence. But there are others who argue that these efforts run afoul of the Constitution by interfering with the President's ability to control the executive branch and to make sure that the laws are faithfully executed. I hope that both those who view these bills as constitutional and those who express their doubts that they're constitutional can agree on one thing. There is a robust role for Congress in overseeing the executive branch, including all investigations conducted by the Department of Justice appointed special counsels. The American people also play an oversight role and can apply political pressure to any president who removes a special counsel for reasons that they do not consider adequate. Finally, the Constitution gives Congress the ultimate check on the executive branch through the power of impeachment. Every American has a right to expect their government to be ethical, effective, and accountable. If there is one thing that I've learned in my career as both a farmer and as a senator, it is that where the sun pokes through, there can be no darkness. I have spent my career as a strong advocate for openness and transparency in government, but I also believe that the separation of powers is essential to preserve the liberties that we Americans enjoy. I look forward to today's hearing. Senator Feinstein.
Thank you very much. Let me, if I might, Mr. Chairman, start with a correction of my earlier remark. The letter I mentioned on the intelligence sharing with this committee was sent to the Director of the CIA, Mike Pompeo, and was signed by both the chair and ranking member of this committee. We sent it yesterday, and I'd ask that it be incorporated in the record.
It'll be in the record.
Thank you very much.
Without objection.
And thank you for calling this hearing to address the two bipartisan bills to protect the integrity of the special counsel. Today, under current Department of Justice regulations, the special counsel, as everybody knows, cannot be fired for anything but misconduct, dereliction of duty, incapacity, conflict of interest, or other good cause. Those regulations have been in place since 1999 and were meant to ensure integrity and impartiality when Department of Justice has a conflict of interest. They have been in place during both Democratic and Republican administrations, and neither their necessity nor efficacy has ever been seriously questioned. Both of the bills we are considering today provide extra layers of protection for the special counsel. They were introduced on the heels of reports that President Trump was contemplating firing special counsel Bob Mueller, a man who has broad bipartisan support and who has served this country with honor and distinction. I think my colleagues from both parties agree that firing Mueller would be a grave mistake. For example, Senator Graham, star of stage, screen, and radio now, has said that unless special counsel Mueller did something wrong, firing him, and I quote, could be the beginning of the end of the Trump presidency, end quote. And Senator Markey has gone so far to say that doing so would be, quote, a full-blown constitutional crisis. Firing special counsel Mueller would be that much more concerning, given widespread understanding that individuals close to the president, or even the president himself, have tried to tip the scales of the Russia investigation. We've all heard President Trump's reaction when Attorney General Sessions recused himself from the Russia investigation. Even though the Attorney General acted properly, the president berated him because the recusal led to the appointment of the special counsel. Several months ago, we also heard from former FBI Director James Comey, who testified before the Senate Intelligence Committee that he felt pressured by the president to, quote, let Flynn go, end quote, and to, quote, lift the cloud, end quote, even though an FBI investigation was ongoing. Simply put, I have strenuous concern about President Trump's respect for the rule of law. The president must know that Congress will not stand idly by if he attempts to undermine independent criminal investigations. Turning to the bills themselves, first, they both require good cause before the special counsel may be removed. This means that the Attorney General could not fire the special counsel absent some sort of misconduct, illegal act, or violation of Justice Department policies. Secondly, if the Attorney General finds good cause to remove the special counsel, both bills allow a court to review that finding. The two bills differ a bit. The bill introduced by Senators Graham and Booker and co-sponsored by Senators Whitehouse and Blumenthal would require a court to determine that good cause exists before the removal of the special counsel. And the bill introduced by Senators Tillis and Coons would allow the special counsel to ask a court for reinstatement after the fact if the removal was not for good cause. That bill also provides that if the Attorney General is recused, only a Department of Justice official confirmed by the Senate could fire the special counsel. We are joined today by a panel of distinguished legal experts, and I very much look forward to this discussion. I expect much of it will cover Supreme Court precedent and whether the precedent applies to today's situation. While precedent is certainly important, excuse me, in this discussion, I'm hopeful that we won't let a discussion of legal theory prevent us from speaking about the real-world problems these bills address. We are aware that in 1973, President Nixon wanted to fire Special Prosecutor Archibald Cox, who was conducting the Watergate investigation. But the Watergate Special Prosecutor could only be removed by the Attorney General, and only for good cause. Nixon's order to fire the Special Prosecutor led to the Saturday Night Massacre and resignations of Attorney General Elliot Richardson and Deputy Attorney General William Ruckelshaus, who both determined there was not good cause to fire Cox. Although Cox was ultimately dismissed, it was not before two Justice Department officials had sounded the alarm on President Nixon's interference with the investigation. That is proof that protections like the ones we are discussing today are not only necessary, but they also work. If past is prologue, what we are discussing today could not be farther from being merely theoretical. With that, I will turn to the chairman.
Thank you. Senator Feinstein already referred to our panelists as distinguished panelists, and I've noted, my staff has noted for me, all the publications you've all done. And if I refer to every one of those publications, you'll never get a chance to give your remarks. So I'm going to give a relatively short introduction of each of you, but you can go to the record. Everything that is in my opening remarks will be in the record, so you know that I have absorbed that you are all well published and very distinguished in your professions. Our first witness is Professor Akil Reed Amar, Sterling Professor of Law and Political Science at Yale University, where he teaches constitutional law. He has also won awards from the American Bar Association and the Federalist Society, and is a recipient of Yale's highest award for teaching excellence. He has been favorably cited by the Supreme Court in over 30 cases And then he has authored dozens of law-reviewed articles that I'm going to put in the record. Our second witness is Professor Eric Posner, the Kirkland and Ellis Distinguished Service Professor of Law, University of Chicago. He writes about and teaches legal theory and constitutional law, including the law of presidential powers. He has written more than 100 articles at academic journals and more than a dozen books, including 2 of the presidential power, one entitled The Executive Unbound, After the Madisonian Republic, and then he's published in various important newspapers and other articles, and those will be put in the record. Our third witness, Professor Stephen Valdick, professor at the University of Texas School of Law. Senator Cornyn, I hope you weren't, I was going to introduce these folks. Was I supposed to give deference to you?
No, sir.
Okay.
Go ahead, Mr. Chairman.
Professor.
I'm glad to have somebody from the University of Texas Law School here today. We discussed FISA reauthorization in the line at Southwest Airlines yesterday in Austin. So, so I'm glad to have him here. Thank you, Jay.
Professor Stephen Vladeck, a professor at the University of Texas School of Law, where he teaches federal jurisdiction, constitutional, and national security law. His works have appeared in a variety of news forums and legal publications, including Harvard Law Review and Yale Law Journal, and the rest of that will go in the record. Our final witness, Professor John Duffy, Samuel H. McCoy, Professor of Law, and Elizabeth D. and Richard A. Merrill, Professor of Law at the University of Virginia Law School. He teaches tort, administrative law, patent law, and international intellectual property law. He has also served as articles editor for the University of Chicago Law Review and was awarded the Olin Fellowship in Law and Economics. Professor Duffy, clerk for Judge Stephen Williams on the U.S. Court of Appeals for the D.C. Circuit, and for Scalia, served as attorney advisor in the Department of Justice Office of Legal Counsel, and practiced law at Covington and Burlington. He has also published much. The committee has also received a letter from Professor John Harrison, the James Madison Distinguished Professor of Law at the University of Virginia Law School. In it, Professor Harrison expresses his views that both of the bills that we are considering today would encounter significant constitutional difficulties, and that letter will be put in the record. We'll start with you, Professor Omer.
Thank you, Mr. Chair. It's an honor to be with you all. I've previously testified before this committee on half a dozen occasions, and it's a great privilege and always a solemn responsibility to be with you. The 2 bills under current consideration, the Graham-Booker bill and the Tillis-Coons bill, aim to thwart potential presidential abuses in connection with attempted removals of special counsels, including the possible removal of Robert Mueller. The bills have laudable goals, and it's heartening to see bipartisan sponsorship here. Several of the bill's co-sponsors are my dear friends. I have no such personal relationship with President Trump, whose wings the bills aim to clip. I'm a registered Democrat who publicly opposed Mr. Trump in the 2016 campaign, and I am distressed by many of the things he has done and aims to do. That said, I must sadly report that as a scholar who studied the Constitution, I believe that the bills in their current form are unwise and unconstitutional. It gives me no pleasure to say this, but I need to be straight with this committee. Happily, I think there are alternative reforms that actually are more constitutionally proper and more likely to actually achieve the laudable purposes of these bills to restrain improper presidential behavior. In a nutshell, I think that the bills are, if enacted, likely to be successfully vetoed, are likely to be judicially invalidated, and are in any event violations of several basic constitutional principles. So my preferred alternative, in keeping, Mr. Chair, with what you said, the one thing we can all agree on, you said, is that there's a robust role for Congress in overseeing the executive branch, and I actually think that this body itself has more resources and would be better advised to use some of its own cameral powers than to try to punt things over to the judiciary in the way that these bills try to do. In a nutshell, if the bills were to reach the president's desk, I think he might be very inclined, of course, to veto them. That's going to be hard to overturn. Only twice since 1952 has a president who controlled both houses of Congress had his veto overridden. He's likely to be backed by an OLC memo, by a broad range of public opinion leaders. He will claim that he's defending the presidency more generally, and various public opinion leaders, I think, would back him up on that, and it would boomerang. Instead of actually chastening him and checking him, this would actually, unfortunately, empower him. Were the issue to reach the courts, and I think there is a disagreement among these very distinguished panelists, I count 6 likely votes for invalidation. And we can go through my reasons for that in more detail if the senators are so inclined, and that too would actually end up boomeranging and backfiring rather than accomplishing the need to chasten and check this president or any president who is tempted to abuse power. In a nutshell, the Constitution says that someone like Robert Mueller, who's not confirmed by this body, is constitutionally an inferior officer. It is very hard to be both inferior and independent at the same time. It's like a square circle, and these bills try to make someone who is inferior also independent, and constitutionally that's a problem. Technically, the reason that he's independent right now is he actually can be sacked. He can be fired within the executive branch. Here I channel many of the things that Justice Scalia said in his most famous opinion, the Morrison versus Olson opinion, but I go beyond that, and my written testimony is, of course, available to you all. Now, my proposed alternative, in the spirit of the Federalist 51, is to actually have a standing bipartisan committee of this body, equally balanced, like the Senate Ethics Committee is, a standing committee on presidential oversight, and this committee would aim to basically institutionalize a true separation of powers rather than a mere separation of parties. You wouldn't be acting as Republicans and Democrats as such, but you'd be acting as senators checking the executive. You'd be channeling the best thing about these bills, which is their bipartisan structure. Instead of punting things to the judiciary, and I know my time is up, you'd be emulating the judiciary at its best when in McCulloch, Chief Justice Marshall reaches out across the aisle, and Sebelius, John Roberts reaches out across the aisle. You could be doing actually what the judiciary has done at its best, Earl Warren in Brown, rather than punting things to the judiciary itself. Thank you, Mr. Chair.
Thank you, Professor Amar. I should have told all of you that your full statement will be put in the record. You've probably been told that, but I want everybody to know that 5 minutes is a short period of time for all of you folks that write so much, so, it'll be put in the record. Professor Posner.
Good morning, Chairman Grassley, Ranking Member Feinstein, and distinguished members of the committee. Thank you for providing me the opportunity to testify in special counsels and the separation of powers. I've evaluated the 2 bills under consideration today, and I conclude that they do not violate the principle of separation of powers, but on the contrary, advance important constitutional values. Now, Senator Feinstein has mentioned the Saturday Night Massacre to us, and I want to bring this a little bit back to life, especially for people who were young, as I was when it took place. On Saturday, October 20th, 1973, President Richard Nixon ordered the Attorney General to fire Archibald Cox, the Watergate special prosecutor, who had earlier issued a subpoena for the Watergate tapes. When Attorney General Elliot Richardson refused and resigned, the President ordered Deputy Attorney General William Ruckelshaus to fire Cox. The Deputy Attorney General also resigned rather than carry out the President's order. The president then asked Solicitor General Robert Bork to fire Cox. Worried about a leadership vacuum in the Justice Department, Bork swung the axe. The Saturday Night Massacre converted the long-simmering political crisis over Watergate into a full-blown constitutional crisis. 4 years after Nixon's resignation, Congress passed the Ethics in Government Act of 1978. A provision of that law created a new kind of special prosecutor, later called the Independent Counsel, who could be fired only for good cause, was given significant operational independence, and was appointed by a panel of judges. A major goal of the statute was to ensure that a constitutional crisis, like the Saturday Night Massacre, would never occur again. The law accomplished that goal over the roughly 20-year period it was in effect, despite the recurrence of significant controversies over executive branch wrongdoing during the Reagan and Clinton administrations. Congress allowed the independent counsel provision of the Ethics in Government Act to lapse in 1999. Critics had argued that the law created too many independent counsels who spent too much money investigating unimportant matters. The question today, however, is not whether to revive the independent counsel, but whether to give special counsels selected by the Attorney General and subject to Department of Justice regulations, which is why they are inferior officers, protection from removal except for good cause. Over the years, many people have raised questions about whether Congress is allowed to put limits on the president's authority over law enforcement. They argue that such limits on the president's executive power violates the principle of separation of powers. The Supreme Court decisively rejected this argument in a case called Morrison v. Olson in 1988. In a 7-1 decision, the court ruled that the independent counsel law did not violate the separation of powers. The reason was that the law did considerable good by enhancing the integrity of investigations of the executive branch, while it only modestly restricted the president's executive power. Since the bills under consideration today restrict the president's power far less than the independent counsel law did, these bills passed constitutional muster as well. Now, not everyone agreed with the Supreme Court's opinion. As Professor Amar noted, Justice Scalia, the single dissenter, wrote a powerful opinion that has won much praise. But there are good reasons why Justice Scalia did not persuade any of his colleagues. First, Justice Scalia claimed that the Constitution gave, quote, complete control over law enforcement to the president, and so any attempt by Congress to influence law enforcement violates separation of powers. However, this was not the understanding at the founding, and it is certainly not true today. The Constitution itself gives Congress power over law enforcement explicitly in the text through appointments and its power to define offices, its power to control budget as well, and Congress has used that power over the years in many ways. Second, Justice Scalia claimed that an independent counsel is unaccountable. He cannot be punished for misusing his power. Meanwhile, the president can be. As Justice Scalia put it, the president is directly dependent on the people, and since there is only one president, he is responsible. The people know whom to blame. But the Watergate burglary was an act of political espionage, one of many that helped President Nixon win re-election in 1972. The people could not punish Nixon at the polls because they did not know about the lawbreaking. Securely in power, Nixon pursued a course of obstruction of justice that may well have succeeded were it not for the inadvertent discovery of the tapes. Let me conclude. The idea of separation of powers is that each branch should check another branch if the latter abuses its power. Watergate showed that the executive may abuse its power by refusing to investigate its own lawbreaking. Congress's constitutional obligation is to check the executive branch by providing a means for ensuring that an investigation takes place and is done fairly. The Special Counsel Independence Act and the Special Counsel Integrity Act take an important step in this direction. Indeed, they will more likely enhance executive power than undermine it because they reassure the public that the officers of the executive branch, including the president himself, are not above the law.
Thank you, Professor Posner. Now, Mr. Blatty.
Great. Thank you, Mr. Chairman. Senator Feinstein, distinguished members of the committee, it's an honor to be back before you today. Rather than rehash my written statement, I'd like to take my time this morning to make 3 points that hopefully help to crystallize the areas of disagreement among the witnesses. So first, with regard to the current special counsel regulation, I hope you'll forgive me if I refer to it as Part 600. It's worth highlighting what I see as the major ways in which it's far less intrusive vis-a-vis executive power than that which was true about the independent counsel statute. First, under the regulation, the power of appointment belongs to the Attorney General, or as in this case, the acting Attorney General in cases in which the Attorney General is recused. There's no judicial role in appointment or in the initiation of an investigation, contra the independent counsel statute. Second, if there are concerns about the scope of the investigation, if the special counsel seeks to enlarge his jurisdiction, if the Attorney General is concerned about whether the investigation is going too far afield, the Attorney General makes the final decision about any questions of jurisdictional scope. That matter, too, is not subject to judicial review. And third, with regard to removal, Senator Feinstein already pointed out, the regulation specifically provides that it is the Attorney General, again, or in this case, the acting Attorney General, who makes the removal decision, again, in contrast to 3 judges of the Special Division of the D.C. Circuit, as was true under the independent counsel statute. If the largest concern folks had with the independent counsel statute was the specter of a runaway prosecution, which many think we saw in the 1990s, there really is no meaningful chance of that under Part 600 as it's currently drafted. My second point, with regard to the 2 bills, I'd like to underscore how modest they are against that backdrop. So if we recall, during the Saturday Night Massacre, there actually was a lawsuit brought on behalf of Special Counsel Cox seeking to enforce the then-in-place regulation and contest whether he was lawfully removed. That did not require special legislation from Congress. That was a declaratory judgment and injunctive action. And Judge Gassell ruled that, indeed, then Solicitor General Bork had violated the then-in-place regulation by removing Special Counsel Cox. There's already a mechanism in place for a special counsel or someone to sue on his behalf to challenge wrongful removal. As tweaked, both bills simply guarantee that review and improve it by invoking a 3-judge district court and the automatic right of appeal to the Supreme Court that comes with it. And my third point, with regard to the Supreme Court's jurisprudence, which I gather is perhaps the principal point of departure between the 4 of us, the claim that Morrison versus Olson is bad law is, to me, simply unsupported by the record. In contrast to the widely held view that aspects of the independent counsel statute were simply a bad idea. I think we too often conflate those who think statutes were bad policy with those who assume they must therefore have been unconstitutional. Indeed, I disagree with my colleague and mentor, Professor Amar, that there are 6 votes among the current justices to overrule Morrison. I'm not sure how you even get past 3. Even if there's less support for Morrison, though, let me go back to my first 2 points. These bills are so much less intrusive than the independent counsel statute was. The real concern that they seem to animate is with the regulation itself. And I'm hard-pressed to see why these would be the vehicle through which the current court would seek to revisit prior precedent, given that all the bills do is guarantee a right to judicial review that may very well already exist. In closing, Mr. Chairman, let me just sort of turn back to Justice Scalia's Morrison dissent. I think Justice Scalia's dissent is rightly celebrated for its style, for its passion, and for how well written it is. But that doesn't mean he's right. And instead, I actually think I'd use a quote from the end of his dissent to point out the importance of this whole enterprise. Justice Scalia closed his Morrison dissent by reminding everyone of the text of Article 30 of the Massachusetts Constitution of 1780, and the maxim that ours is a government of laws and not of men. It seems to me that the special counsel is an important, if limited, manifestation of that really important principle, and that ensuring a mechanism for protecting the special counsel from wrongful termination is, at a time when we very much need it, simply further to that laudable, desirable, and hopefully bipartisan goal. Thank you, Mr. Chairman. I look forward to your questions.
Thank you very much. Now, Professor Duffy.
Chairman Grassley, Ranking Member Feinstein, and distinguished members of the committee, thank you for inviting me to testify before you today. My analysis today is necessarily tentative because the Supreme Court precedents on the removal issue have not been consistent. Indeed, the court seems to have a curious habit of abandoning its own reasoning whenever it confronts a new major case in the area. In the court's 1935 decision in Humphrey's Executor, it abandoned the reasoning of its decision just less than a decade earlier in the Myers case. In 1988, the Morrison versus Olson case explicitly threw overboard the entire reasoning of the Humphrey's Executor case. And in 2010, the Free Enterprise Fund case did not quote or apply the functional analysis endorsed in Morrison. The holdings in all 4 of those cases remain good law, at least currently, but not necessarily any of the reasoning. With such judicial variability, I have to balk at making definitive predictions about the court's future course, which I think is a fair point. Turning to the bills, 1735's proposed transfer of removal authority from the executive to the judicial branch seems unconstitutional if the court adheres to the Free Enterprise Fund holding. Under 1735, a special counsel would enjoy statutory tenure protection unless and until the Attorney General could convince life-tenured Article III judges that the counsel should be removed under one of the statutory grounds for removal. That removal system seems to impose two levels of tenure protection between a special counsel and the president. Under Free Enterprise Fund, such multi-level protection is unconstitutional. Indeed, the removal system under 1735, to the extent it differs from Free Enterprise Fund, presents additional problems that militate even more clearly against sustaining its constitutionality. I believe, however, that 1735 is directed toward a legitimate policy goal, which is to provide an orderly process to test the legality of a removal order without the brinksmanship of a disruptive removal order of uncertain legality, such as the one issued in the so-called Saturday Night Massacre. I think that the proposed legislation could be modified so as to be constitutional if it were to require that any order of removal not take effect for a period such as 14 days, to borrow the period from the other proposed legislation. To preserve the executive's prerogatives, the legislation should also provide that the special counsel's authority would be temporarily suspended during that period of time. That 2-week period would provide time for seeking judicial review and for the court to grant any appropriate preliminary equitable relief. Legislation requiring such a process would be well within the mainstream of existing precedent and broadly consistent with the existing practice in administrative law. With respect to S. 1741, the most constitutionally troubling aspect of the bill is that the combined effect of sections 2B and 2E would together change the regulatory tenure currently afforded to a single known officer into statutory tenure. There are no clear precedents supporting such a retroactive grant of stronger tenure for an existing officer. In my written statement, I cover certain analogous precedents that suggest that such a retroactive strengthening of tenure might be unconstitutional. Furthermore, the selectivity of the section, the targeting of a single official, makes the provision look more like an unconstitutional attempt to circumvent the executive's power to control appointments for particular offices. I recommend that the retroactive provision be deleted, or if it is maintained, that the subsection be made separately severable. In the event that a court holds Section 2E, the retroactivity provision, unconstitutional, a severability clause would allow the bill's procedures to be used for other legal challenges, such as the challenges heard in the Nader versus Bork case that was mentioned by my colleague here from Texas. One last point, the mandatory reinstatement remedy in Section 2D3 goes beyond the remedy allowed in prior Supreme Court cases and even beyond the remedy authorized in the Independent Counsel Act. I recommend that that section be modified to track the Independent Counsel Act and give power to the court to grant reinstatement or other appropriate relief. Thank you for your time and attention to these issues, and thank you again for the invitation to speak to the committee.
We will have a 5-minute round for questioning to Professor Duffy and Amar. As you know, both bills codify regulations on for-cause removal and permit judicial review. In your opinion, are either of these steps necessary for Congress to ensure that the special counsel investigation is conducted properly, or are Congress's oversight and impeachment powers enough? Start with you.
I believe that it is that the change from regulatory tenure to statutory tenure is not needed if you're asking the policy question of whether the regulatory tenure would be sufficient to ensure a degree of independence for the special counsel to conduct the investigation. That regulatory tenure, I think, is likely to be respected by the Department of Justice officials, except and to the extent that they begin to see difficulties or conflicts of interest or other causes that might require removal. And that information is likely to be closely guarded inside the Department of Justice because it will deal with the operation of the investigation, which is matters not really public, not known generally to the members of the public.
Okay, Senator or Professor Marr.
I'm a fan of congressional oversight, and I think it's actually a better mousetrap than trying to make a statute that codifies the good cause removal standard. One thing that makes the good cause removal constitutional at present is, from a formal legal point of view, it could be rescinded by the executive branch. So the executive's choosing to bind itself, and that's part of what makes Robert Mueller technically an inferior officer. But if you put it in a statute, how is he actually constitutionally inferior? Cabinet officers can be fired at will, and yet this person, can't be, and he's supposed to be inferior. The Morrison case, you had Alexia Morrison investigating one person who was out of office, Ted Olson. So maybe that person was inferior. Here, you've got someone investigating the President of the United States for possible obstruction of justice and finding the director of the FBI, as well as other people possibly involved in a major national scandal involving alleged Russian tampering with a presidential election. Oh, it's hard to say that that person is actually in any way inferior if you actually statutorily require these limits on removal. Again, cabinet officers are superior, the principal officers, and they can be actually fired at will. And there's the pardon power that interacts with all of this, which is an important element. Congressional oversight by this committee or a standing committee of some sort, I think, is the far preferable way to go.
I have another question that's a little bit out of the purview of this hearing, but very central to oversight responsibilities of this committee that I'd like to ask you if you could comment on it, each or all of you. According to recent press reports, Deputy Attorney General Rosenstein has been interviewed as a fact witness by Special Counsel Mueller's office. He reportedly provided them a copy of the president's initial memo justifying the removal of FBI Director Comey and was questioned about it. Do you believe that poses a conflict of interest, and should Deputy Attorney General Rosenstein consult the ethics officials at the Department of Justice about the issue? If you could comment, I'd like to have your opinion.
I haven't investigated that sufficiently to give you actually a good answer, Senator, Mr. Chairman.
Is that the same for all of you? Okay. Then let me move on. That's something, though, that's very bothersome to this committee. I want to bring that up. For Professor Vladeck, Posner, and Amir, S-1735 requires the Attorney General or Acting Attorney General to submit his removal decisions to a 3-judge panel, making a finding that the removal of special counsel is appropriate under 1735 for cause provision. 1741, on the other hand, permits the special counsel himself to seek review of any removal decision. In your opinion, is the approach taken by 1735 or 1741 preferable from a constitutional perspective?
I'll take that first, Mr. Chairman, because I addressed that a bit in my written testimony. I think it would be safer to take the approach where the initiating complainant is the special counsel. Let me just illustrate that with a hypothetical. Imagine a case where the special counsel doesn't even contest that the Attorney General, in fact, has cause for his removal. I don't know what is gained by having the Attorney General go through an unnecessary judicial process. So I think it's not necessarily a violation of Article 3 to have the Attorney General go first, but I think it makes a lot more sense to have the Attorney General notify the special counsel that he or she believes there are grounds for their removal, and if the special counsel objects, have him or her be the one who then initiates the litigation under both bills.
Okay. Professor Posner.
Yeah, I like the symbolic impact of the rule in 1735. I'm not sure it matters in practice. Imagine, for example, that the president or the attorney general or acting attorney general fired the special counsel without going through the court under 1735. Then the special counsel would bring a case in front of the court anyway, saying you violated this law. Even if the court had concerns about whether the law is constitutional, it would still hear the case. It would hear the case because there's an allegation of a violation of the for-cause removal provision. And so in the end, you're going to get judicial review, whichever bill you use. But it is true that the provision in 1735 is a little bit more unusual, so it's a little harder to predict how a court will react to it.
And Professor Amar, if you have anything to add.
Well, I respectfully think that both are problematic. And remember, since we're talking now about courts getting involved, the Solicitor General of the United States presumably would be representing the executive branch. I believe, actually last week, I could be wrong, that the Senate confirmed Noel Francisco to that position. He is, I believe, a former law clerk to Justice Scalia. He might very well have a view about unconstitutionality that, if that were to pass, the Senate might need to retain its own counsel and be involved in that. And now you're putting the whole thing in the lap of the judiciary rather than actually taking control of the matter yourself, which you would be able to do actually with a robust oversight process where you would be the ones and the cameras of the world would be focused on your deliberations about whether this stank to high heaven or not. And ideally, you would do it in a bipartisan way, in a manner somewhat akin to the Senate Ethics Committee, where you by rule have equal numbers of both parties, and I think that would just be a much better way of oversight. Since Watergate has been invoked on a bunch of occasions, remember in Watergate, in real time, the judges didn't reinstate Archibald Cox. Leon Jaworski wasn't sacked. It was actually politics and congressional oversight that actually worked. And it worked in Teapot Dome also. It worked better.
Senator Feinstein.
Now I'm really confused, so let me try to sort this out. Do you acknowledge that the two special counsel bills are narrower than the independent counsel statute? Could we go yes or no down the line?
Certainly not the first, certainly not 1735.
I'm sorry, Professor, thank you.
Certainly not 1735, which requires on its face that the executive branch go to the judiciary in order to get permission to remove. The independent counsel statute did not have that structure. Instead, the attorney general issued the order of removal him or herself.
Okay, and 1735, just so everybody, is Graham, Booker, Whitehouse, and Blumenthal.
That's, yeah.
Mr. Bladek?
I think that is what Professor Duffy mentions is the only respect in which I think either of these bills is more of an intrusion than the independent counsel statute. I mentioned in my testimony, I think there are three critical substantive ways in which it's much less intrusive. The attorney general has control over the appointment, the scope of the investigation, and the initial removal decision. So I think it's actually much narrower in all three of those respects, all three of which Justice Scalia relied upon in his Morrison dissent as problems with the independent counsel statute.
Mr. Posner?
1741 is clearly narrower than the independent counsel statute.
Let's see, which
And
one? 1741. Is
That's
that
with the
Tillis?
yes, Tillis Coons. And then 1735, in my view, is also narrower because, as I mentioned earlier, I don't think these judicial review provisions, as a practical matter, will make much difference.
Do you believe it's constitutional?
Yes,
Both.
both are constitutional.
Professor?
In general, both are considerably narrower. There is the technical issues that Professor Duffy raised, but I don't think those are of the essence. Those could be tweaked. So in general, it is narrower, but still unconstitutional, in both in my view and as I count votes.
The statute on the books is unconstitutional.
The statute lapsed, Senator, in 1999, the ethics in government, and it lapsed because Janet Reno came, then Attorney General, came before the Senate of the United States, and if I could just tell you what she told
Please.
this body, because it's actually pretty important, and it's in a note in my testimony. And she had originally supported the Ethics in Government Act in 1978, and she came reluctantly to the position, and this is very much where I am, that it's unconstitutional. Here's what she testified on March 17th, 1999, quote, "After working with the Act, I've come to believe, after much reflection and with great reluctance, that the Independent Counsel Act is structurally flawed and that these flaws cannot be corrected within our constitutional framework. The independent counsel is vested with the full gamut of prosecutorial powers, but with little of its accountability. He has not been confirmed by the Senate. Accountability is no small matter. It goes to the very heart of our constitutional scheme. Our founders believed that the enormity of prosecutorial power and all decisions about who and what and whether to prosecute should be vested in one who is responsible to the people. That way, quote, and this is all a quote, and here I'm paraphrasing Justice Scalia's dissent in Morrison v. Olson, whether we're talking about over-prosecuting or under-prosecuting, the blame can be assigned to someone who can be politically punished." So that's why, that was her testimony, that bill was flagrantly unconstitutional and it lapsed thanks to a sunset provision, as Professor Posner mentions in his testimony.
Now, I'm a non-attorney, so I'm going to put it in non-attorney language.
Sure.
Which bill between Graham Booker and Tillis Coons do you believe is the soundest on the basis of constitutionality? And I'm going to go down the row with this, and being able to carry out its purpose properly.
I think neither, because I think both would be judicially invalidated. So you're not going to...
We have nothing.
If working with these, I offer a different way of skinning the cat.
Okay, let's go down the line, because I don't want my time to run out. Mr. Posner.
They're both valid under the Constitution. I think they're equivalent. If I had to choose one, I would choose the Tillis Coons one because it avoids this judicial issue that people have mentioned, but I think they would both easily be upheld by the Supreme Court.
Mr. Laydick?
I agree. I would just say, in my testimony, Senator, I actually proposed a slight tweak to Graham Booker that would avoid the Article 3 problem that I think my colleague was just referring to. I think the real question, if you, like Professor Posner and I, think they're both constitutional, is what's preferable, having the special counsel remain in place while he is challenging his removal, or have this period of potentially weeks or months where the special counsel is removed and it's unclear what's happening while that litigation is taking place. So I have a policy preference for Graham Booker, and I think the one unique constitutional issue it raises could easily be solved through drafting, as I discussed in my testimony.
Professor Duffy?
I think both are unconstitutional, but for different reasons, in the sense that the 1735 bill has this problem of going to the judiciary to seek permission. I think the 1741 bill has this problem of retroactively changing the tenure of an existing officer. And since you're targeted this specific investigation, you can't really modify the 1741 bill without having it inapplicable to the current special counsel Mueller, which is, I think, the overall thrust of the committee's bills.
You know, again, I'm not a lawyer, but if I hear you correctly, you're saying, well, currently there's no protection, that the special counsel cannot be fired. And you're saying that there is a degree of unconstitutionality to the two bills, but the Graham Booker bill, is that the bill that's most likely to survive a constitutional test in your view?
No, the Tillis Coons one is more likely.
The Tillis Coons. Could we go down, Professor?
Again, I think
that's where this is with me.
So we could talk about the individual, my reasons for the vote count, but I think neither one will survive a Supreme Court challenge, in which, by the way, Solicitor General Noel Francisco will be the one up there tasked with, and you'll need probably your own
We'll have
counsel.
nothing. Mr. Vladek?
I think just Professor Duffy's objection to 1735 is the objection that I suggest in my testimony could be fixed easily through a friendly amendment that just has the special counsel be the one who initiates the lawsuit as opposed to the Attorney General. So I actually think if tweaked the way I proposed in my testimony, they have the same chances because it's an up or down question about Morrison versus Olson.
I think 1741, which is the Tillis-Coons bill, probably many of its procedures could be, might be, I think, are constitutional under Morrison versus Olson. The court might likely strike down the retroactive provision, but then it would go forward with the procedural provisions about hearing the challenges, and there will be other challenges, such as the ones that were raised in Nader versus Bork, to any removal order.
Thank
so
you.
that would procedurally.
Thank you. No, I'm totally confused. Go ahead. Thank you very much.
Senator Lee.
Thank you, very much. Thanks to each of you for being here. I think this is one of the most overlooked issues in our system of government, the question of separation of powers. Anytime we tinker with the division of power within the federal government, between these three branches of government, we do grave damage to the system. This damage is not abstract, far from being an injury that is solely institutional. This type of injury, I believe, has profound consequences for individual liberty. Ultimately, it's what separation of powers is about. It's why I was so thrilled to hear Professor Amar's reference to Federalist 51. Ultimately, government is perhaps the greatest reflection on human nature. If we were angels, we wouldn't have a need of government. If we had access to angels to govern over us, we wouldn't need all these rules. But we're not angels. We don't have access to angels to govern over us, so we have to have rules. When we deviate from the separation of powers, and when you consolidate in the same person or group of people the power to make and enforce laws, it inevitably ends in tyranny. In fact, according to Charles de Montesquieu, it is the definition of tyranny. It's what tyranny is. When the same people who are making the laws are also enforcing them, you've got a big problem. And so one of the questions that I have specifically regarding this set of legislative proposals would be what counts as good cause? On what basis could someone be removed? Now, both of these bills say that a special counsel is permitted to be removed based on, quote, misconduct, dereliction of duty, incapacity, conflict of interest, or other good cause, including violation of policies of the Department of Justice, but not limited to those things. Now, as a lawyer myself, I have a pretty good idea of what incapacity is. That's a judicially manageable standard. We know what that means or can mean. We know how we would go about deciding what that would mean in court. Conflict of interest, there too. But good cause, what does that mean? Could good cause amount to what happens when, say, the Attorney General says, drop this case, and it isn't dropped? Could it mean that there is good cause when the Attorney General says, don't issue that subpoena, and the subpoena is issued anyway? What's your reading of that, Professor Amar?
Thank you, Senator. Since you mentioned the founders, George Washington directly orders, this is on March 13th, 1793, he writes William Raleigh, instructing Raleigh, quote, to enter a nolle prosequi for the indictment aforesaid. And John Adams did that, directing line prosecutors what to do and not do. So did Thomas Jefferson, one involving William Duane and another involving Anne Greenleaf. And I do believe that when the president gives a lawful order that is within the discretion of a lower level official in the executive branch, if that person is really an inferior officer, defiance of that lawful order would be good cause, but the statutes don't say that. They say, well, if you violate the DOJ's regulations, that's good cause, but they don't specify that when two options are lawful, you can do A or you can do B, and the president directs you to do A, and instead you do B, the statutes are not at all clear that that's actually good cause. And I think that raises a serious constitutional problem, because if that's not good cause, then what Washington did was unconstitutional or was problematic, or Adams or Jefferson. And so president can't tell someone to do something illegal, but within the zone of lawful discretion, if someone is really an inferior officer within the executive branch and hasn't even been confirmed by the Senate, there is a real problem, and these bills actually exacerbate that problem.
Professors Posner and Vladek, in the time I have left, what's your response to that?
Well, Senator Lee, as a lawyer, you know that many legal concepts are vague and then they're filled in over time. Incapacity is actually vague. What if Mueller, for example, became ill and could work sort of, but not too much? Would that be grounds for removing him? Good cause, we can easily think of examples. If he's fired in order to obstruct justice, that's not good cause. If he's fired because he's not showing up to work and not doing anything, that would be good cause. If it's in the middle, at that point, we would have to trust a court to evaluate the reasons that were given and make a judgment accordingly.
And I just add, Senator, very briefly, I mean, I think it's worth stressing that in this context, the ambiguity of the phrase is pro-executive branch, right? Because the ambiguity of the phrase, I think, leads to the conclusion that courts would interpret good cause fairly capaciously to actually allow the Attorney General, or in this case, the Acting Attorney General, to come up with plausible, not illegal grounds. To me, that is a feature of a good cause removal provision that actually gives broader discretion to the executive branch than if the regulation simply stopped after misconduct, dereliction of duty, et cetera.
Okay, my time's expired. I hope I have the chance to follow up on this in a subsequent round. Thank you.
Senator Leahy.
Thank you, Mr. Chairman. Thank you for having this hearing.
That's one.
You know, we were just going through the completion of work of special counsel and others the year I came to the Senate. I've heard a lot of discussion since then. Many of us had questioned the utility of Kenneth Starr's years-long, multi-million-dollar meandering investigation into President Clinton. A dogged insistence on sexual conduct they did not show when he was the head of Baylor, and much worse things happened. But there's no doubt that the underlying independent counsel statute didn't violate the separation of power. Morrison versus Olson, 7-1 decision made that clear. Now, I think that the two bills under discussion today, produced by Senators Graham and Tillis and others, are even more modest. So, Professor Posner, in your view, what would be the true threat to the rule of law? One, if one of these two bills is enacted in law, or secondly, if the president disregarded the existing Justice Department regulations to fire the special counsel in order to undermine a Russian investigation?
If the president ignored if one of these bills was enacted and the president ignored, well, we'd be back to Watergate, where there are a number of issues here. One is the president or any high-level executive branch official not being investigated because of basically a problem of self-dealing in the executive branch. That's inherent in our system to some extent, and it's Congress's obligation to ensure that this self-dealing is limited as much as possible. I should add, by the way, that Teapot Dome was mentioned. There was another special prosecutor who was appointed in, I think, 1951 during the Truman administration, a man named Newbold Morris. He was appointed to investigate corruption in the IRS and the Justice Department. He was fired by McGrath, the Attorney General, at Truman's request, and the investigation was never completed as a result. So that's the thing that we have to worry about. That's what motivated the independent counsel statute. If the independent counsel statute did produce unnecessary investigations, that's not a problem here because the Attorney General retains the power to make the appointment in the first place.
Let me ask you another way that the President of the White House could undercut it, or think they could undercut it if they cut back the budget of the special counsel. And you had noted that in an op-ed that was in the New York Times. If he wanted to interfere with the Russian investigation, he could attempt to undermine the special counsel's budget. I looked at that because I'm vice chairman of the Appropriations Committee, and we have Congress's budget and appropriation powers. Can't Congress assert a role in ensuring that the President or Attorney General or Acting Attorney General cannot undercut or eliminate the funding for the special counsel?
Yeah,
Do we not have the power of the person?
you do have the power. You do have the power. Under existing regulations, the Attorney General determines the budget of the special counsel and could request $0 for the special counsel if that's what he wants. Congress could step in and appropriate money for the special counsel. That is within Congress's power. The president would be required to spend it.
We have, incidentally, we talked about protecting the special counsel without running afoul of the separation of powers doctrine. I know there's been some disagreement here, and I appreciate that. But suppose we pass no law whatsoever, and even if the current regulations protecting the special counsel somehow didn't exist, obstruction of justice is always a crime, no matter what. Am I correct in that? You all agree with that, correctly? Am I correct? So, and I note that everybody shook their head yes. Professor Vladeck, is it a basic protection for the special counsel if the president fired him to improperly influence a Russian investigation? Doesn't that raise a question of obstruction of justice?
I think it does, Senator Leahy, and I think that the existing regulation already goes a fairly long way toward protecting the special counsel's ability to investigate that very offense. As I've mentioned, I actually think it's possible that the existing regulation would be sufficient for the special counsel to try to enforce if he were removed without good cause. So, the real question here, I think, is not akin to the independent counsel statute where Congress is creating this entire structure. The Justice Department has voluntarily created this structure, right? The question is how best to ensure that it's honored and that it's not abused to hide crimes by those connected to the administration.
And Professor Amar, you had said that no man can be a judge in his own case. What does that say about a president's ability to pardon himself?
He has no such power. I'm long on the record as discussing that, but since you mentioned the pardon, you see, and it connects to Senator Lee's question, suppose he says, well, I'm pardoning this person and that person. They happen to be in my administration. They happen to be my former campaign head or friends or relatives. And I'm doing it so that the country can move on. We're spending too much money. This is distracting from other things. That the accountability in the end, there is the pardon power. And so the accountability in the end has to be impeachment and press oversight and Senate oversight. But I don't think judges can actually undo that. And judges can't quite decide whether that's good cause or not. The pardon power actually means at the end of the day, the president can choose not to prosecute pot smokers in Colorado or other folks.
We're getting a bit off my question. My question was...
He can't pardon himself.
Thank you very much. I just want to make sure we had the answer. And I'd ask me to put my other questions and my statement on the record.
For the record will stay open for a week, so you might get questions for answer in writing. And statement will be in the record. Now, I have Republicans down this way, Graham, Cornyn, Tillis, and Kennedy. So if there's any disagreement with that, let me know. Senator Graham.
Thank you, Mr. Chairman. Thank you for having the hearing. So let's remind ourselves why we're here. Do all of you agree that Attorney General Sessions made the right decision to recuse himself from the Russian investigation because he was part of the campaign?
I have no opinion. I'd have to look through the facts of that, and I've just read press reports, which I'm not sure are accurate.
So far as I understand the facts, yes.
Yes.
So far as I understand the facts, it was sensible.
Yeah, I think the Attorney General made the right call because it's going to be pretty difficult to have the Attorney General investigate the campaign of which he was integrally involved. So that's the start of all this process. So once the Attorney General steps aside, you got the Deputy Attorney General. We all agree that he could take his place and continue if he's not conflicted. Is that a yes from everybody?
Yes.
Yes.
Then we had a statement by the President and some actions by the President that unnerved the Deputy Attorney General and he appointed special counsel. Do you all agree with that?
Yes.
Yes.
Yes. That's how we got here. We got here because Sessions said, I can't do this, I shouldn't do this. Rosenstein says, I will do this. Then some things happened between President and Comey where Rosenstein said, well, we need some new person, a special counsel, to look at this. That's how we got here. All agree with that?
Yes.
What we're trying to do is make sure we move forward and hold Mr. Mueller accountable, but also give him a protection to do his job. So do you all agree that the president himself cannot fire Mr. Mueller?
Actually, if you read even the op-ed by our mutual friend Neil Katyal in the Washington Post, who actually helped write the regulations, he says that's not altogether clear.
Okay.
It's not clear that the regulations themselves actually apply to the president as opposed to merely figures in the Department of Justice.
Do you think he has the inherent authority to fire this guy?
He may very well claim that, and both Professor Katyal and I think that that's not settled either way.
Okay, what about you, Professor Posner?
I believe that a court would reinstate the special counsel under constitutional principles, but I do agree that scholars and others would be uncertain.
Mr. Vladeck.
I agree. I would just point out that the Supreme Court has held multiple times that the executive branch in toto is bound by regulations that it itself promulgated until it properly rescinds them. You know, I agree the Supreme Court has never said, therefore, the president can't
In
fire.
English, you don't think he can. All right.
I try to avoid English wherever possible.
I know. You're doing good. Mr. Duffy.
I would think he does have the de facto power because he could order his representatives at the Department of Justice to repeal the regulations, which I think would be
Right.
They would.
That'd be a two-step process.
Yes.
Yeah, it would be a two-step process.
Or he could fire people until he finds an acting attorney general who would, in fact, fire the special counsel.
So do you understand what we're trying to do is we're trying to make sure that something out of bounds doesn't happen and Mr. Mueller can proceed forward with some confidence. Is that a thing worth the Congress looking at, given the circumstances we have? Do you think we're doing the right thing by trying to look at that?
I think you are, in part because I think that providing a process, an orderly process of judicial review might actually strengthen presidential power and make the president more certain that if there is something that is, you know, legitimately good cause, or the president believes it's good cause, the president can issue an order and not have brinksmanship, not have
Right.
Saturday Night Massacre.
So here's what I'm trying to avoid, is a Saturday night massacre and a upheaval into the country that I think would be hard for us to get over. Now, I want the president to know that there is a process in place and there are checks and balances long before you got here, and they'll be there long after you're gone. So you got two ways of doing this. Under our approach, basically, before the special counsel is terminated, we ask a judicial panel to evaluate the reason given by either the president or the acting attorney general. The other solution is, after he's terminated, to reinstate. Mr. Vladeck, you said you think our approach is better because it allows the investigation to move forward, less upheaval. Do you still stand by that?
I do. I do. I would just propose the tweak I mentioned in my written statement to have the special counsel initiate the proceeding.
I think that's actually a good suggestion. Mr. Posner, you said both of them are probably constitutional. Do you agree that keeping the special counsel in the game in terms of the investigation provides the most continuity?
Yes, I agree, and I prefer the Graham-Booker bill on policy grounds for that reason.
Well, to the public, I'm a Republican. I want to make sure Mr. Mueller does his job. If he gets off script and if he does something wrong, there will be a way to look at what he's doing. He's not above the law either. But I just want everybody in America to know that he's going to do his job without fear of reprisal. He's going to do his job, protected as much as we can by a legal process. This is not about President Trump. It's about any president at any time in the future being able to be held accountable as an individual. And there's nothing more important to me than to say, without hesitation, that everybody in America, including the president, is under scrutiny when there's an allegation they may have done something wrong. And that's what this is all about.
Senator Whitehouse.
Thank you very much, Chairman. Professor Amar, welcome. You say in your written testimony, and I'm quoting here, the power to pardon subsumes the lesser power to decline prosecution for any number of reasons. Can this lesser power you describe be regularized by the president into policy so that the folks who are actually enforcing the laws have a specific direction from the president as to that lesser power to decline prosecution?
Yes, and it's typically subject to revision. So, for example, President Obama could basically say, we're not going to pardon people who violate, arguably, federal laws in Colorado on possession of marijuana.
So it's subject to revision, but
Yes.
it's not unconstitutional for a president to say, we're not going to prosecute, for instance, the DACA kids.
And DACA is a little trickier because it's not on the criminal side fully. Some of that is civil non-enforcement, but yes.
But the power
for
of the president
but for
is the same
criminal,
in that respect.
excuse me?
The power to choose to enforce is equally executive in either case.
Yes, but with criminal, it interacts with the pardon power in a way that it doesn't on the civil side. Otherwise, you can have, for example, private prosecution on the civil side, antitrust laws and the like, and you can't have that on the criminal side. So there's more power of non-prosecution on the criminal side.
So, first of all, Professor Posner, welcome. Do I understand that you're the son of Judge Posner?
I am, yes.
Let me tell you, I think it's a great loss for the judiciary that he retired. He had an extraordinarily distinguished career, and I think was one of the historic judges. So
Thank
pass
you,
on
Senator.
pass on my compliments.
I will.
I have 3 questions that I'm not going to ask you all to answer right now. As the chairman has said, you have the ability to reflect on these things and then answer as questions for the record. But I'd like you to reflect on 3 things. The first is, it's been said in this hearing that the president can't order an official to do something illegal. Does that mean that it is unlawful for the president to order an official to do something illegal? And if it is unlawful to order an official to do something illegal, is there a remedy, a legal remedy for that? And obviously the context here would be that the firing of the special prosecutor would in fact be an act of obstruction of justice. So that's question 1. Question 2, there is a certain amount of debate over the role of grand juries. I don't think anybody's testimony here has touched on the role of grand juries, but there is at least an open question whether the grand jury is the instrument of the prosecutor or whether the prosecutor is the instrument of the grand jury. As I understand it, once a grand jury is sitting, the grand jury has the ability to tell a prosecutor to go pound sand, and they're not going to give them subpoenas. They have the ability to demand subpoenas and witnesses, even if the prosecutor doesn't want to produce those subpoenas and witnesses. The U.S. Attorney's Manual describes the grand jury as an independent body of government. So how does the prosecutor, in his role, potentially as the servant of a grand jury, engage in this whole separation of powers question? It's a little bit of an interesting wrinkle that I think we should not overlook. We're doing a great job in this country right now of overlooking the constitutional role of juries and grand juries. Our founding fathers, I think, would be stunned and horrified. And I think that puts an extra, at least a wrinkle into this analysis. Once you have a prosecutor who is now the servant or the instrument of a grand jury, does that affect in any way the ability of the purity of an executive authority to terminate? The third is the 25th Amendment, Section 4, which says that the vice president and a majority of the principal officers of the executive departments can actually remove all executive powers from the president. They can, at least temporarily, displace him from office. So if the vice president and a majority of the principal officers of the executive department have the power to remove all powers from the president, would it not be at least logical to presume that a similar body, consisting of the vice president and a majority of the principal officers of the executive department, have to sign off on the firing of special counsel? Would it be closer to the constitutional scheme if you avoided the judiciary entirely and established that that same panel that is already in place under the 25th Amendment had a voice in this decision, and that the lesser power to say to the president, hold off there, you can't fire this guy while he's investigating you, is subsumed within the greater power of removing all powers from the chief executive? Those are complicated questions, and I look forward to your responses in due course. And I appreciate the erudition and expertise of this panel, and I thank the chairman.
Senator Tillis.
Thank you, Mr. Chair. Thank you, gentlemen, for being here. I think in some of the opening comments, since I'm one of the sponsors of the bill in question here today, that I talk about my motivations. Professor Amar, you and I probably could have a beer together, but I doubt we'd see eye to eye on many ideological issues. But I have to go back and explain what my motivation for this bill was. I think that at the time back in August, we had a lot of things that were going before this committee over the past year or so. We've had a significant degradation, I believe, in the reputation of our FBI and our Department of Justice over the past 8 or 9 years, where there were a lot of people calling into question what's going on in what I consider to be the greatest law enforcement entity that's ever existed. But it was degrading in the public consciousness. So my motivation for this bill, and Mr. Duffy, you said something that I think is important because we have the retroactive date. It's something that we've already decided would have to come out if this bill moves forward, and simply say that it's applicable to anybody in the role after this bill is enacted. But my motivation was actually to remove the distraction and to eliminate what I thought was a spiraling of the narrative out there that was not based in any factual, anything in the record, I should say, that this president intended to remove the special counsel. It became something that just spun up through social media, everything else. I don't know of any actions the president took that people could say that he was moving to remove the special counsel. My goal was to get something out there to discuss that maybe there is an opportunity for us to assert some level of a check and balance in place. And it's very difficult to do that when you're in the majority. Generally speaking, people advocate for these bills when they're not in a position of majority. And particularly when your president is of the same party. And I thought it was important for the purposes of other matters that we should bring before this Congress for somebody to step out and do it when it's difficult, not just when it's easy. But Professor Amar, when you may have made public statements against this president's election, I was campaigning for him. I generally support his policies, and I think this president will do well as the commander-in-chief. But there is a role that we have to play to just kind of lower the temperature and let the processes play out. That was my primary motivation for filing this bill. And I'd like to believe that there are members on the other side of the aisle that if they were in my position, if this were President Clinton, and there would have most likely been some sort of investigation going on because of the meddling of the Russians in the election, I don't think anybody disputes that they would have had the courage and the conviction in our role in this process to put forth that bill and withstand the public outcry in some cases from my side of the aisle for not supporting this president. I support this president completely. Now, I also think that we're not here to clip any one president's wings, but to create a sense of a check on any future president. Now, I want to go to you, Mr. Duffy. I do believe that the retroactive provision is something that makes sense to take out, and it would make that more consistent, I think, with Senator Graham's and Senator Booker's bill. Another thing that we talked about, because in our originally proposed bill was more or less codifying the rules that existed in the DOJ, and I'm wondering whether or not it would also make sense to move to a point where we're saying that you simply have to follow whatever rules are in place at the time the action took place. In other words, not codifying for posterity the rules that exist today, but as things change, how do you think that either makes our proposal better or worse?
Well, there's two alternatives to that. One, you could say that they have to follow their own rules that are in place at the time of firing. And I actually agree with Professor Vladeck that that's already the law because the Supreme Court has said agencies must follow the rules. But that would be kind of weak because you could then repeal the rules. Mm-hmm. So I think what you would say is it has to follow the rules that existed at the time of appointment. And that, again, has a certain retroactive effect, which I've discussed in my written statement, and I think that is constitutionally troubling. I will say that the procedures to actually get fast judicial review, which are sort of shared by the two bills, slightly different ones, I think are a good idea and would bring some degree of certainty to the process. And the retroactivity provision, you just make that separately severable because there would be other claims like the ones that were adjudicated after the firing of Archibald Cox. There'd be other claims that could be brought in any kind of action. They should be adjudicated all together and done so rapidly as suggested in your bill.
Thank you. My time is up. We are going to submit, thank you all for your opening statements. We are going to submit questions for the record, and I appreciate you all being here and weighing in on this. Thank you, Mr. Chair.
Senator Klobuchar.
Thank you, all of you. Professor Posner, in your written testimony, you describe Watergate as the greatest constitutional crisis in American history since the Civil War. When we discuss the history of Watergate, I think the most concerning part of it for many Americans is the concept of government officials believing that they were above the law, not accountable for unlawful activity. What set Watergate apart from other abuses of presidential power?
There were, I would say, two elements. First, the sheer magnitude of what the Nixon administration had done, including a burglary of a defendant, Daniel Ellsberg, in a criminal case, political espionage of all kinds. There had been dirty tricks of various sorts in the past by other presidential campaigns, but the Nixon campaign was significantly worse. And then second of all, the obstruction of justice, which was outrageous, pervasive, it's hard to exaggerate how significant that was. Other presidents may have hesitated about appointing special counsels in particular cases. As I mentioned, Truman fired a special prosecutor, but the lies and the extent to which Nixon and his aides covered up these crimes were unprecedented.
Now, in his dissent in Morrison, Justice Scalia talked about how there would be political checks, right, on a president in such a case. And you point out the shortcomings of this view in your written testimony, for instance, that Nixon did not face another election. Can you talk about how the independent counsel law was intended to rein in those types of abuses?
Right, so the problem with this view about political checks, impeachment can occur, but that's of course very difficult. The president might face another election, but in Nixon's case he did not. And I also want to emphasize that the whole point of political espionage during an election campaign is to undermine political checks. That's what it's doing. You're spying on your opponents so that you can get an advantage over them. If you succeed, the voters can't hold you to account. They don't know about it. They don't know that they've been deceived. The independent counsel statute tried to correct this problem by creating a special prosecutor, later called an independent counsel, who could not be fired and who had much more independence than the current special prosecutor does because of worries that even if he couldn't be fired, the Justice Department or the White House would in other ways try to influence his investigations.
Thank you. Professor Vladeck and maybe Professor Amar will want to chime in, and if I don't ask him a question, my daughter will be angry since he took his class on constitutional law. In your testimony, Professor Vladeck, you talk about how the special counsel regulations go a long way toward providing an important check. I asked Deputy Attorney General Rod Rosenstein about this and how these regulations work. Could you answer that in 30 seconds, and then I'll go to
Sure.
Professor
I think the check built into the regulations is the removal provision, right? That the special counsel, although his jurisdiction is controlled by the Attorney General, he can only be removed for the reasons set out in 28 CFR 600.7D. I think that's the check. And I think that's, we're here today because the question is, how do we ensure that that check is more than just a paragraph on a piece of paper?
Okay. Professor Amar. Do you want to add something?
Say hi to Abigail for
Okay,
me,
I will.
please.
That's on the official record now.
Thank
Like
you.
that.
She's trying to decide whether she wants to be a lawyer or a comedian, so I told her she has to talk to your colleague.
Yeah,
from-
and I know you
Estelle.
showed her photos of college classmates who had decided to pursue comedy and didn't do very well.
Right,
There's like
right. I
mugshots.
thought her
That was
parents
really
might want-
effective because she then didn't go to law school. But
Yeah, so her parents tend to want people to go, their kids to go to law school rather than to be comedians. But and I know Senator Franken's coming up here. I do think that there is a big difference between having something in a regulation where the executive branch has chosen to limit itself, and when you try to put it in a statute, that really does raise some very serious constitutional concerns. And it's going to have to be defended in court by the Solicitor General, and he's not maybe going to and survive a presidential veto, and so it may just be a big waste of time, whereas you all on this, in the world's greatest deliberative assembly, can monitor presidents when they misbehave, and you can decide what's good cause and not good cause, not some judge. And I would say that actually, if you did that in a bipartisan way, the entire country would stand up and applaud.
Thank you.
Senator Kennedy.
Thank you, Mr. Chairman. Gentlemen, you guys remind me so much of law school.
Uh-oh.
And why I sat on the back row. I've listened with a lot of interest. You all are obviously experts on the law. I'm assuming you have opinions about the efficacy of the implementation and execution of that law as well. What kind of job do you think Congress has done so far in investigating the alleged activity of Russia in our election?
In my written testimony, thank you, Senator, I suggest that although technically the House of Representatives is the body that initiates impeachments, it's by its very nature a very partisan body. Because you have single-member
Unlike the Senate.
Yes, I actually argue that the Senate is actually structurally the place where America has to come together, because most members of the House of Representatives have districts that lean far left or far right, and and they're only 2 years away at most from a primary where they have to be worried about their base.
Right. So what kind of job do you think Congress has done so far?
Well, the Senate is better structured than the House, and you could be better structured still if you create mechanisms that build bipartisanship into the oversight. So, okay, so far, I'm a tough grader, so maybe a B. I think you could, if you work hard and revise, you can get an A.
Yale was pass-fail.
First semester.
How about you, Professor Posner?
I really don't feel I'm qualified to evaluate what Congress has done. I will say that in Watergate, both Congress and the judicial system were absolutely essential. They were complementary. They helped each other. And that is why the cover-up was uncovered.
Professor?
Very good.
If we're giving grades, I'd give an incomplete, right? I think there's, Professor Posner mentions Watergate. I think that example is a powerful example of how there are moments, even in our modern times, where the separation of parties is more powerful is less powerful than the separation of powers. I'm not sure we're there yet. I think, I have concerns about, for example, statements that the chairman of the House Intelligence Committee has made related to this investigation, right? So, the history books are written after the fact, Senator, and I think there's still time, but so far, pretty incomplete.
Professor?
I think the most important thing this body should look into is any allegation or any possibility that anyone, Russian activists or non-state actors, could actually hack the voting machines. That would undermine the credibility of the entirety of the election. I think that other allegations that seem to be made that perhaps, ads were purchased by other people, I think those politically are just simply less important than the question of did the machines count the right votes. Professor Posner said that the voters could be deceived if, let's say, an ad were purchased on Facebook. I think it hard to believe that after a lengthy campaign where hundreds of millions of dollars were spent and the American people got to see the live debate between the two presidential candidates, that they were deceived about the differences between those two candidates. However, the voting machines, that is of primary importance.
Well, it seems to me that there are a multitude of issues here, but there are two main ones, at least in my mind. And that is, first, to what extent, if any, and I just add that if any to try to appear to be fair, to what extent did Russia try to interfere in our electoral process? The second issue is, did anyone conspire with Russia in doing that? Now, I see the special counsel looking at the second issue, but I see Congress's obligation is to look at the first issue. Do you think we've used all our powers in looking at the first issue, or have we been too deferential to the special counsel?
Senator, you're allowed to look into both issues, and I think both issues are worth looking into.
I agree. You should look into both issues. In the Watergate era, the Senate and the House looked into the conspiracy issues.
Yes.
And that was a key part of the series of events that led to President Nixon's resignation.
And I would just add, Senator, until either House or committees thereof are subpoenaing witnesses who aren't going to testify and are actually exercising their full enforcement and oversight powers, I think there's more to be done.
And I agree you have the power to look into both issues and to subpoena people with respect to both issues. I just hope that the priority of the issue, not just for this campaign, but for all future campaigns, is the integrity of the voting counts, because that is something that goes beyond just this election or this campaign. It goes to all future.
But as I understand what you're saying, then I'm going to hush, Mr. Chairman. Until we stop acting like a bunch of weenies and subpoena people, then we're not going to get what we need. Is that what you're saying?
That certainly seems to be the historical experience.
Okay.
Senator Blumenthal.
Thanks, Mr. Chairman. I think there are two questions. The Russian interference in our election, which has been established by the intelligence community beyond doubt, and then potential collusion or conspiracy involving the Trump campaign. But there is a third question now under investigation by the special counsel, which is whether or not the President of the United States or any official under his supervision is obstructing justice, whether the President of the United States is interfering with the lawful enforcement of the laws of the United States, which would be a violation of criminal law. And put aside the legal niceties, the special counsel and the president right now are on a collision course. We're headed toward a constitutional confrontation between the special counsel and the president, which is evidenced by the threats that the president has made against the special counsel, the comments that he made to the Russian foreign minister about feeling relieved after firing Comey because he was free of the Russian thing, the Air Force One statement that he dictated as the explanation to be given by his son, Donald Trump Jr., for the June 9th meeting involving not only his son, but his son-in-law and his campaign manager with Russian foreign agents. A slew of evidence now under investigation and more that cannot be disclosed here involving potential obstruction of justice. And so the question is, how do we preserve the rule of law? How do we make sure that the President of the United States is not above the law, which was also the question in Watergate? And that is, in some sense, an enforcement question. The good cause standard, which is now in the regulation and which would be in the legislation that my colleagues and I have drafted, has to be enforced by someone. And normally in our democracy, it's the courts that enforce the law. And so I take your point, Professor Amar, that congressional oversight is a good thing, but Congress doesn't enforce the law, and it has some supervisory jurisdiction over justice. This committee, in fact, has that oversight responsibility over the Department of Justice and the FBI, which is why we are conducting our own investigation. But a grand jury is an arm of the court that provides the special counsel with some protection, but ultimately this constitutional confrontation that looms very close can be avoided only if the law is enforced by a court. And I see Morrison as firmly upholding that reasoning by a 7-to-1 majority. I recognize the eloquence of Justice Scalia's dissent, but it is a dissent. I recognize, Professor Duffy, that the court may not have a perfectly consistent line of reasoning on these kinds of cases because it is complex and because it is political. What I would like to know, Professor Amar and anyone else after you, is how you would avoid this constitutional confrontation without the court's involvement.
So on the first point, 2 points. One, so he fires Mueller. Mueller gets reinstated, and then he says, fine, I'm pardoning everyone, and he can pardon everyone other than himself constitutionally. And unless the American people are outraged, unless this Senate actually conducts oversight, Richard Nixon, even after the Nixon tapes case actually was handed down, had the lawful authority to pardon John Mitchell and Ehrlichman and Haldeman and all the others. So because that pardon power is so vast, at the end of the day, what prevented that was the press, the American people, and this body, the Senate of the United States, that ultimately said, we're not going to let that stand. So you actually have to be part of the process, even if courts are.
After there is a finding of fact, after the investigation concludes, after the special counsel is permitted to do his work about whether or not there was a violation of law, and then perhaps only impeachment is the remedy. You're talking about the remedy, not the special counsel function of fact-finding and investigation. Special counsel is a fact finder and investigation, and the fear that our proposal is designed to address is that that fact finding will be aborted, it will be cut short, it will be ended unlawfully, and that the American people will never know what happened. The president does have the pardon power, and I grant you it is unlimited, apparently, and we can talk about the possible limits that may apply on the pardon power. But ultimately, an investigator, an enforcement officer, which I was for many years, uses a grand jury or other investigative tools to make findings of fact and to possibly disclose those facts that may lead to remedies, whatever those remedies are. And there can't be remedies unless there are findings of fact. I know my time has expired, Mr. Chairman, and I hesitate to cut short any of the distinguished witnesses that we have before us. I would never do so in their classrooms, but I appreciate your indulgence. Thank you. And if any of the witnesses are permitted to answer those questions, I'd be delighted to hear them.
In 15 seconds or less.
Caspar Weinberger, even before there were findings of fact. So the pardon power really looms over all of this.
I would say that the impeachment power is the ultimate power for that specific thing, and you get to try cases of impeachment once the House impeaches.
Right.
Nixon could have pardoned his henchmen. He might even have been able to pardon himself. That was considered. He did not. Okay, so there are grave political constraints on using the pardon power, which is why all these other things we're talking about are so important.
And I just don't know why we're so afraid of the courts.
I want to apologize to Senator Coons. I actually skipped the order. Senator Blumenthal, you not only got to go first, you got to go over 2 minutes. Senator Cruz.
Thank you, Mr. Chairman. Gentlemen, welcome. I welcome a distinguished panel of respected academics who've done important work. I want to start with just a general question. Morrison versus Olson, was it rightly decided? Did the court get it right?
No, I think it was clearly wrongly decided on multiple grounds, and since it seems very important, you all really depend on good whip counts, because that's important. So we're actually talking about actually counting votes, and I count them differently, and so 4 times Justice Thomas has actually, in 4 different opinions, cited the Scalia dissent, including last term. I see Justice Gorsuch as being very much of the same view, although he hasn't been on the court so long, but just on the basis of everything that he says and the way he approaches things. Our great mutual friend and colleague, Senator Lee, is no longer here. I would defer to him on Justice Alito, for whom he clerked, but I count that as 3. Now, Chief Justice Roberts actually twice has cited the Scalia dissent with strong approval, once in a case that Professor Vladeck actually was involved in. It's mean, but on the losing side. So that's 4. Here's what Elena Kagan said, actually, and justices on the Supreme Court don't usually, sort of talk very publicly, but this is what she said at Stanford in public remarks in 2015, quote, the Morrison dissent was, quote, one of the greatest dissents ever written, and every year it gets better. Now we have Justice Kennedy, who was part of the majority in the PCAOB case and actually writes Zivotofsky. Yes, Senator Blumenthal is no longer here. He said it was 7-1. 75 years ago this year, the Supreme Court in a landmark decision, or this coming term, in a case called Barnett, which is one of the great cases of American liberty, actually said you can't be forced to salute the flag, shades of stuff that's going on today in the NFL. But that overturned the Gobaitis decision, which was 8-1 just 2 years before. Morrison, Bowers versus Hardwick was overturned in Lawrence versus Texas. So you have to, and the court hadn't said that it was going to beforehand. So you have to see these overturning coming. So I actually do predict that if you passed either of these bills, there is a very serious, you can't be sure, but a very serious threat. And I haven't even talked about Justice Breyer, for whom I clerked, who is, very pro-Senate, having been general counsel on this committee. But wrongly decided. There are many different things. Not everything Scalia said was right. I agree with my distinguished colleague here that there's some things wrong, but on a whole bunch of things, what he said actually was sound, and today's Supreme Court would follow him, especially on what an inferior officer is. See the Edmund case.
The opinion was correctly decided. And if the question is whether these bills will be struck down by the Supreme Court, one of these bills, because the Supreme Court will say, we just blew it with Morrison versus Olson.
And let me clarify, my question is much more as a matter of first principles under the Constitution, because we have an obligation to follow the Constitution, whatever interpretations may come from the court.
So Morrison versus Olson was correct because the court recognized that the independent counsel statute was strengthening the executive branch by enhancing its credibility, or if it weakened the executive branch, that was justified by the important goal of preventing the president or others in the executive branch from breaking the law.
I think there were 2 features of the independent counsel statute that were really bad policy. I don't think that makes it unconstitutional, and I think the decision was rightly decided.
I think the appointment of the independent counsel by the courts is the most troubling, and I think that the Justice Scalia was right to say that it was unconstitutional on that ground. The good cause removal, which we've discussed a lot here, I think could be construed in a constitutional fashion precisely because it is a vague standard, and therefore it can be construed consistent with standard principles of statutory construction to avoid any potential serious question of unconstitutionality, because it could be construed to preserve the supervisory authority of the Department of Justice officials.
Professor Amar, Professor Posner argues in his written testimony that Congress has already restricted the president's power over law enforcement through civil service protections. Do you agree, number one, that civil service protections are constitutionally valid, and then number two, If so, how would you respond to that analogy?
Thank you, Senator. So civil service actually doesn't always apply to officers of the United States, but actually only to employees. The remedy is not always reinstatement. Sometimes it's just actually back pay, and I do talk about that, Senator, in my testimony. In any event, in order to be constitutional, Robert Mueller has to be inferior. This is what Justice Scalia said emphatically, and then he reiterated for a majority of the court in Edmund. Inferior means inferior. It means having a superior. It doesn't mean small. It means inferior to someone else, inferior to a superior. There are courts inferior to the Supreme Court, and if he can't be fired at will, it's hard to say he really has the superior. If he doesn't have to actually follow the direct orders of the President of the United States within the lawful discretion that he has, it's hard to say he's inferior. Words matter. Inferior means inferior, and in my testimony, I completely concur with your view that even if I'm wrong about Morrison, you have an independent obligation about constitutionality, and if I could be so bold, every week I actually tell my undergraduates that, and I actually invoke your name, because even though you and I don't agree on all what the Constitution means, we actually believe that senators have an independent obligation to take the Constitution seriously, and I've always admired that feature of your service, sir.
Senator, that sounds like a terrible abuse of law students.
Senator, I'm a tenured law professor and employee of the state of Texas. It's very hard to fire me. I am not a principal officer of the state of Texas.
I would just add that the special prosecutor position is a creation of the Justice Department. The budget is controlled by the Justice Department. The investigative steps that the special counsel takes can be vetoed by the Attorney General or the acting Attorney General. There are many respects in which he is an inferior officer, and of course, the good cause removal provision does not prohibit him from being removed. It just prohibits him from being removed for bad cause. So that's another reason, another respect with which he is inferior to the Attorney General.
Thank you for your illuminating testimony.
Senator Coons.
Thank you. I'd like to thank Chairman Grassley and Ranking Member Feinstein for holding this hearing. I'd like to thank our experienced and constructive panel for your testimony today. And I'd like to especially thank you, Senator Tillis, for your partnership in crafting and introducing this Special Counsel Integrity Act. And I'm also grateful to a number of other colleagues, Ranking Member Conyers and Congressman Jones for introducing a bipartisan companion bill in the House, and Senators Graham and Booker, Whitehouse and Blumenthal, and Representative Jackson Lee. The fact that this group of members from across the ideological spectrum from both chambers have engaged in legislative efforts to try and provide some modest, effective strengthening of the special counsel, I think shows that this goes beyond temporary partisan concerns and reflects a deeper concern, something that reaches past the importance of Special Counsel Mueller's ongoing investigation, itself an important issue for all Americans, and goes to the integrity of our government and to the rule of law. I respect and share Senator Tillis's statement at the outset that our motivations in moving this bill forward go beyond what is just in front of us in terms of Special Counsel Mueller, and reflects a much deeper commitment to rule of law. So I'm also pleased that more than a dozen groups and individuals have written us expressing their support for the value of this legislation. I'd like to submit for the record a letter to that effect without objection. And if I might, just to pick up where some of that questioning just was from Senator Cruz, Professor Vladeck, is it possible for commentators, including even a justice, to praise Justice Scalia's dissent in Morrison, yet it's still to be good law? In fact, I think you've said the Supreme Court has cited Morrison dozens of times without overruling any portion of the decision. Is that correct?
Yeah, and I would just say, I mean, so Professor Amar mentioned Justice Kagan in the speech he gave at Stanford. You know, I went back and reread then Professor Kagan's 2001 Harvard Law Review article on presidential administration, where she goes out of her way to say that she thinks the unitary executive theory at the heart of Justice Scalia's dissent in Morrison is wrong. And so I don't know why we can't simultaneously be of the view that there are great opinions written by justices in history with which we disagree on the constitutional law.
So if I could ask just bluntly, is Morrison good law?
To me it is, and I think to a majority of the court it has been.
Let me ask, you made an important, I think, statement earlier, which is that all these two bills do is guarantee a right to judicial review that already exists. Could you just briefly explain that?
Sure. I mean, so I mentioned the Nader versus Bork case from 1973. You know, the Nader versus Bork case is based on the theory that when you have a regulation protecting then the special prosecutor, that regulation is judicially enforceable, whether through a declaratory judgment or through a suit for injunctive relief. And indeed, Judge Gassell ended up holding in Nader versus Bork that Acting Attorney General Bork violated the regulation when he fired Special Prosecutor Cox. I think you could make the same argument about the existing regulation Part 600, that 600.7d actually could be enforced today if, in fact, the special counsel were removed. The tricky part, and I mentioned this in my testimony, Senator, there's a provision in the regulation, I think it's 600.10, that I think could be argued to prevent such enforcement. That provision did not appear in the Watergate era regulation, so it would be an open question as to what role that has on the ability to enforce the regulation today.
Some could argue, if I could, Professor Posner, that the special counsel bills we're talking about are significantly less intrusive on the power of the executive than the independent counsel statute that was at issue in Morrison. Can we just take a quick review of those? Justice Scalia in his dissent was particularly vituperative about the idea that the independent counsel was appointed based on a referral from Congress under a very deferential standard and actually approved by a judicial panel. Is that the case now with these special counsel provisions?
No, that's not the case, and that's one of the major reasons why these bills are much less intrusive on presidential power than the independent counsel law was.
So the appointment is different. Is the oversight also different?
Yes, the independent counsel had significant independence, budgetary independence, and independence over investigation. It's somewhat ambiguous whether it even had to follow Justice Department regulations.
And are the removal provisions today different with special counsel than it was with independent counsel, and that the decision remains within the executive branch?
The removal provision is weaker in the sense of more favorable to the president, both in terms of the substance. It includes reasons that were not in the removal provision of the independent counsel. And again, it's entirely within the authority of the Attorney General.
Let me ask you a last area of question, if I might. Scalia's core argument in the dissent is that the president must have complete control over the law enforcement function. Your testimony states the founders never believed that the president should be given complete control over law enforcement, and instead that there are many other restrictions on the president's control of the law enforcement function that exist now, and that there are other instances where there are good cause restrictions on firing, civil service protections, reporting requirements, inspectors general. Could you just briefly explain why that's relevant here as we consider whether or not the protections we are trying to advance violate separation of powers?
Well, yeah, that's a complicated question, but to be brief, many people put a great deal of weight on the founders' understanding of the Constitution. But in this particular case, what the founders' views were fairly ambiguous. There is evidence, though, that they would never have taken the position that Justice Scalia attributed to them. They explicitly, in the text of the Constitution, give Congress various powers and opportunities to control how the president uses his executive power, including by defining offices, for example, the involvement of the Senate in appointments, and of course Congress's budgetary power, which you can use in many ways to influence how the president actually ends up exercising executive power. This idea that the branches are completely separate and autonomous that one sometimes hears is not actually in the Constitution. They're allowed to influence each other in many ways.
Thank you, Professor. I'd like to thank the whole panel. You've given a number of constructive suggestions, some of them more aspirational, some of them more tactical, but in any event, all of them constructive, and I very much look forward to working with my colleagues to advance this legislation. Thank you.
Senator Franken.
Senator Rono, were you here before me? I think you might have been.
I have no idea.
Okay, that's a no? Okay. Well, because I'm kind of having a little difficulty with this issue because it seems to, I'm not a lawyer, I am a comedian, and we didn't discuss this in comedy school. And there are a couple things that I just want to discuss that have been said that may not be completely germane
to the constitutionality of these two statutes, and there seems to be arguments on both sides, and maybe this will have to be decided if we pass these in court. A couple things. Senator Tillis, who I admire for putting this legislation forward, said that Trump has never really threatened Mueller, but I think he has, by saying that he would cross a line if he looked into his finances. Now that, to me, when he says crossing a line, we never quite know what the president is saying at any one time, nor do I necessarily think he knows. But it sounds like a threat to me. And I think that his finances may be very germane, because we know from the Kremlin playbook that part of what the Russian playbook has been, what the Kremlin playbook has been, is to compromise someone, to get their hooks into somebody and be able to use the ability to, if someone's compromised, to control them. Also, I can't remember, but I think it was Senator Tillis that said that if the President Clinton had won, or if Hillary Clinton had won, was president, there'd be investigations into her because of Russia. But I think it's very clear that Russia sided on one side here. I don't think there's any question which side that they were on. So, I believe that if she had won, there would be investigations into her because the House likes to do that kind of thing. I want to also clarify something, that Sessions recused himself, and this is Senator Graham said he recused himself just because he had been with the campaign. I don't think that's why he recused himself. I think he recused himself because he lied under oath to this committee and said that he had not met with any Russians during the campaign, and in fact he had. And I think that's why he recused himself. I don't think he necessarily would have had to recuse himself just simply because if he had not met with Russians, for example. But I think that he kind of forced that situation on himself. Finally, I'll try to get to a question. I don't know why, and this is Professor Amar, why you believe it's settled that the president can't pardon himself, why that is settled, but it isn't settled about whether he can fire the special prosecutor. I would like to get some opinions on that. In fairness to Professor Amar, I would go with him first, but if the others have a comment on that.
Thank you, Senator. The first principle of the Constitution is the supreme law of the land. It's law. The first principle of law is the rule of law. One of the basic principles of the rule of law goes all the way back to Rome, to Cicero. Cicero is that no man can be a judge in his own case, that principle has been, you will see it actually in the Federalist Papers, you will see it throughout American jurisprudence. And so if you can't be a judge in your own case, you can't pardon yourself. It's an impeachable offense to commit treason, bribery, or other high crimes and misdemeanors. Well, if I can't bribe you, you can't bribe yourself. If I can't bribe you to pardon me, you can't bribe yourself to pardon yourself. So that's a pretty basic first principle.
You lost me there.
So you're the president, and I want you to pardon me. I give you money, and that would be an impeachable offense. That's bribery. I'm giving the bribe. The other person would be taking the bribe. Can't do that. But if you're
That's not the part I didn't get.
The part was the bribing yourself.
So now the same person who is the wants the pardon is the one giving the pardon. Well, that's like bribing yourself. You're giving yourself a benefit for personal benefit. So in the same way, you can't be a judge. In your own case, you can't be a pardoner in your own case.
Okay. Does anyone have any other thoughts on that? Because I don't. It just doesn't seem like it's decided.
Oh, it's not clearly decided by, except it's a first principle of jurisprudence.
I would just add, I'm
Or
not
settled. You said it was settled, and settled and decided seem to me to be the same thing.
Settled may not be the right word, so thank you, Senator.
We could have the other witnesses.
Oh, I'm sorry, but I just wanted to
No, I want them to move forward with that one, but then we need to move on.
Yeah, but I wanted to underscore the point that Professor Amar just apologized to me.
Okay.
Just quickly, I'm not sure there really is such a principle that Professor Amar describes, but if there is a non-self-dealing principle in the Constitution, then it would forbid both self-pardoning and firing a prosecutor who's investigating you. The two things are basically the same.
I just think it's, in practical terms, the answer to that question may remain purely academic, because at the point at which the president is purporting to pardon himself, I have to think that that's when the House would seriously consider exercising its impeachment power.
Okay, I understand. Just to wrap up, my question was, I don't get why you think it's settled that the president can't pardon himself, but it's settled, but it isn't settled whether he can fire the special prosecutor. And you just nodded when Professor Posner said that they're the same, but you had them as opposites.
Because we don't know if he fired Mueller, not because of Mueller's pursuing him, but because of Mueller's pursuing Paul Manafort or Donald Trump Jr. or Eric Trump or anyone else. Well, he could pardon those folks, even though they're his friends. You can pardon your brother, and it's been done. So that would raise different issues. So we would need to know why the president was firing or sacking Mueller, and whether that was about saving his own skin or saving someone else's skin.
Okay, I'm sorry. Yeah, I'm sorry.
Senator Hirono.
Thank you, Mr. Chairman. My understanding is that all of our witnesses have said that the two pending bills are narrower than the independent counsel statute upheld in Morrison, other than the pre-removal judicial review. Is that correct, my understanding? So until such time as the Supreme Court does overturn Morrison, that is the law of the land, and Congress can pass legislation such as what we're contemplating. So this is a question for Professors Vladeck and Posner. As we heard in detailed testimony by FBI Director Comey, the president on numerous occasions on one-on-one conversations with him put pressure on him. That's certainly the way that Director Comey, I think, testified as to these meetings that he had, where in one, the president discussed the status of Director Comey's job and told Director Comey, I need loyalty, I expect loyalty. In another meeting, the president pressed Director Comey about his investigation of recently fired National Security Advisor Michael Flynn and said, I hope you can see your way clear to letting this go, to let Flynn go. He is a good guy. I hope you can let this go. So based on, for both of you, based on your focus on constitutional questions regarding the importance of independent and accountable law enforcement, do President Trump's statements to Director Comey in those instances give you pause?
They certainly give me pause, Senator. I think they're alarming statements, whether or not they rise to the level of what federal law defines as obstruction of justice. I'll just point out really briefly, the special counsel regulation expressly contemplates the prospect that crimes of the like of obstruction of justice, perjury, will be committed in the course of a special counsel investigation, perhaps with the intent to interfere with the investigation. So it's already in the mandate.
So would these kinds of comments reinforce for you the need to protect the independence of Director Mueller's investigation?
Certainly.
And what
Yes,
about you?
I absolutely agree. You don't want to allege obstruction of justice until you know all the facts, but certainly this is alarming from that standpoint. And if you believe that the president might fire someone who's investigating him or his close aides, then the natural response for Congress is to try to give that person some protection.
Yes. So I want to get to the president's pardon of Sheriff Joe Arpaio. So the sheriff was convicted of contempt of court for refusing court orders to stop racial profiling. And before the sheriff even asks for a pardon, the president pardons him. It broke longstanding practice of presidents of both parties in several key ways. As I mentioned, the sheriff did not even apply to the Department of Justice for a pardon, has shown no remorse. What's happening now is that the Justice Department is now seeking to vacate Sheriff Arpaio's conviction. Are you concerned that the president's pardon of Arpaio sends a signal, this is for both of you again, to his inner circle not to participate in Mueller's investigation because he would have their back and pardon them, for example, for refusing to testify truthfully in response to a court order?
You know, I think it's a relevant consideration that one would want to worry about, but I guess in the end, you know, they know that he can pardon them. Nixon's aides knew that Nixon could pardon him, and of course he never did, so I wouldn't want to draw any strong conclusions.
Well, the fact that the president pardons somebody who doesn't even ask for a pardon says a lot, I would say. Yeah. Did you want to add something?
Just very briefly,
Yeah.
I mean, I think the Arpaio pardon, Senator, is a very good example of the very real prospect that a pardon could be completely unsupportable as a policy matter and, you know, deserving of a political and public backlash and still within the president's constitutional authority.
Do either one of you believe that the role of the Justice Department is taking in seeking to vacate Arpaio's convictions further reinforce the need to have special counsel with independence from both the Attorney General as well as the Justice Department?
I think there are any number of episodes, Senator, that reinforce the need for there to be some modicum of independence in the Justice Department. I think that's not unique to the last 8 months. I think we see that throughout American history. And so to my mind, efforts to create permissible independence, permissible structures, permissible protections that separate the Justice Department from the politics of the moment are laudable and should be pursued to whatever extent the Constitution permits them.
Do you agree with that?
I do, and I would add, if you go back and you look at the record of the 1999 hearings about whether the independent counsel law should be renewed, a number of Justice Department lawyers testified that they frequently felt pressure of various sorts, not necessarily being bossed around, although that happened, but just they didn't want to investigate their friends, they didn't want to get in trouble with their ultimate boss. So there are concerns about this, there always have been, and that's an important reason to create forms of independence.
Thank you. Thank you, Mr. Chairman.
Senator Lee. Thank you very much, Mr. Chairman. I'd like to start back with you, Professor Posner. Why is congressional oversight not enough? I mean, we've got in the Senate alone investigation going on some of the matters being investigated right now. Why is the opportunity to investigate through Congress's oversight functions not adequate?
Well, again, I would use Watergate as an example. So the real break in Watergate occurred in a courtroom when the Judge Sirica, told the various low-level Watergate burglars that he was going to give them extremely long sentences, 40, 50 years, for a minor crime, unless they started talking about what their superiors had said to them. And so Congress doesn't have that type of power. Nor does the court also, the trial also created a lot of public attention about Watergate. Congress is not always able to command public attention. Indeed, what really broke Watergate was the Saturday Night Massacre. That's when it went from something that people knew about to something that everybody in the country was talking about. And that was, of course, a case where an executive branch official, not a member of Congress, was fired. So there are many reasons why the law enforcement side is very important for this type of problem.
And yet Congress does have it within its power to remove people from the executive branch. Sure. This becomes a political action rather than a judicial action. But we do have that power. And so if the concern is, number one, that Congress can't scare up enough public attention, I'd beg to differ with you on that one if Congress wanted to do it. Number two, if the concern is that Congress won't do it, we have all sorts of additional concerns that arise out of that. That becomes a question for the people, a question that I think would cause great concern in the people. In the few minutes I have left, Professor Amar, I'd like to turn to you. If the president has authority to give a particular order, and the president, in fact, gives that order to someone holding public office under the president's authority, can that be obstruction? If that person doesn't carry out that order after it's given, is that obstruction to remove that person, or is it obstruction to give the order in the first place?
Motivation might be very important. There are all sorts of things that are perfectly permissible, like, for example, voting for a bill because you believe it's in the national interest, but if someone paid you to do it, well, that would be a crime. So obstruction often turns on motivation, but Dean John Manning of the Harvard Law School has argued that actually, in general, it's good cause, and this isn't decided, and that's one of the reasons that good cause, as you mentioned before, Senator, is actually a problematic term. It's good cause to fire someone if you give them a lawful order saying, you have discretion to do X, you have discretion to do Y. I order you to do X and you don't do it. Professor Manning thinks that might be good cause. I think that might be good cause, but the bills don't say that. And if they did, then it would be, I don't think the bills want to say that because they want to create independence. But you can't be both genuinely independent and, as the Constitution requires, genuinely inferior. You can't be both. You have to pick. Congress keeps trying to pass statutes creating independence, and that keeps jamming with the gears that the framers set up. Whether you agree with Justice Scalia all the way down the line, he did emphasize inferior means inferior. He put that in a majority opinion called Edmund that actually commanded a majority of the Supreme Court. That's one of the many reasons I think Morrison is actually very vulnerable because of the Edmund test. Also, judges appointing prosecutors was horrible, even though two of the witnesses have actually said they agree with Morrison versus Olson on its facts, which is violation of separation of powers 101.
Right. So in other words, ordinarily, absent the special circumstances you've identified, if the president can give an order and in fact gives that order, that's not obstruction in the absence of the special circumstances you...
And you have to carry it out, and if you don't, you should be sacked. And if you can't, in good conscience, carry it out, the path of honor and law is to resign.
That begs the question, what do these bills actually do? If absent those circumstances, the president can give that order, and that doesn't amount to obstruction of justice, and a failure to carry out that order amounts to good cause, what's the purpose of these bills?
They're hoping that judges don't agree with you and me and Dean Manning on that point.
I disagree. I think the bills are meant to account for the possibility that you could have a case where everyone agrees that there wasn't good cause and where the firing was purely for, illegal reasons. And so I think if we're at the point where we're debating whether committing an act of obstruction of justice is good cause to remove a prosecutor, I think that if we're even having that conversation, Senator, I think that explains why we're having this hearing and why these bills have been introduced.
Okay, Mr. Chairman, I see my time's expired. I'd like to engage on that last point, if I could.
You're now in a third round. You have 5 minutes.
Thank you. Thank you, Mr. Chairman. The chairman is kind and benevolent, and his state of North Carolina is a wonderful place. If that's the case that you described, where everyone agrees, we've got a problem. If everyone agrees, why isn't that an appropriate moment for Congress to exercise its authority?
Mm-hmm. It may well be, but I guess my concern is why I don't read the Constitution as saying that impeachment is the exclusive mechanism through which the executive branch can be checked in this regard.
I don't know that I disagree with that point, but I don't think that's the point we have to make or the point we are in fact making. I think the other point is not that there is any, we're not asserting that there is any affirmative denial of the existence of an alternative remedy, but the mere existence of the three branches of government and the way they are set up creates that perhaps as the inevitable byproduct.
Mm-hmm. Senator, I agree with that. I mean, to be clear, I mean, none of this is without regard to the political levers, right, that will surely also come to bear if you had a case like that.
Professor Duffy, you looked like you wanted to weigh in.
I think the procedural aspects of this bill could actually be helpful to checking a special counsel, because a president that actually has some substantial cause might actually fear the political catastrophe of something like a removal order being called the Saturday Night Massacre. But instead, this actually gives a very rapid review, and the courts, I think, would construe the good cause, which is vague, consistent with standard principles of statutory construction. They'd construe it to be quite generous to executive power to avoid constitutional questions. And I think the president would say, we could have our day in court, we would likely win that and be more likely to say there's an orderly process to go through and to show that this or a particular special counsel has done something that has exceeded jurisdiction, or has done or has a conflict of interest, or done something else that really mandates review.
And if I may, just really briefly, I mean, and just to amplify that point, I mean, one of, to me, the salutary features of the bills compared to the status quo, under the status quo, I think it's the case that if the special counsel were wrongly terminated, he could bring a declaratory judgment or injunctive action to enforce 600.7D, but he'd have to go to a lone district judge, right, with the ordinary mechanisms of appeal. Both bills, right, create expedited procedures for hearings before a 3-judge district court with a mandatory appeal to the Supreme Court. And so even if you believe, as I do, Senator, that the review mechanism is already in place, this to me is a better, more efficient, and if I may, less likely to draw a sort of outlier district judge way of solving this problem.
But better still, Senator, if I may, since everyone has been mentioning the Saturday Night Massacre, I just have to say the system worked then, and it worked then without an Ethics in Government Act or anything like this, and it worked because the American people and the House and the Senate actually decided what was good cause and what wasn't, and what stank and what didn't. And that worked better, and that's how the framers drew it up on the blackboard.
Just if we're doing the history, and Judge Cassell ruled in 1973 that that acting Attorney General Bork violated the regulation.
Way after the fact. That wasn't actually, you know, what exercised everyone the day after the thing. There was no Ethics in Government Act.
We're going to let Senator Lee direct the discussion in your remaining time.
Thank you, Mr. Chairman. The overriding concern that I have whenever we're talking about this area is that bad things happen when we depart from the 3-branch structure of the federal government. We have one branch that's in charge of executing and enforcing laws. Now, I don't always like the way that every president chooses to exercise that power. I have frequently disagreed with presidents of both political parties and the way they have chosen to enforce or not enforce the law in certain areas. We do live in a time that I think echoes back to us loudly, that the fact that there are dire consequences from departing from that. Those of us who serve in the highly specialized individuals, but they don't work for the people. They can't be fired by the people. People in my state can fire me once every 6 years. People in the House of Representatives can be fired every 2 years. You can't do that. You can't have that kind of accountability with the people who work in the executive branch agencies. Moreover, when you combine the power to make law with the power to enforce law, that complicates the problem even further. That's why these are legitimate concerns, and I think it is not entirely satisfactory to say that either Congress won't always do it right or the president always won't do it right. We know that to be true because human beings are fallible, they're mortal. They may be redeemable, but they're going to make mistakes. And you very often can compound that problem when you depart even further from the system of checks and balances put in place by our Constitution. Thank you very much to each of our witnesses. Thank you, Mr. Chairman.
Thank you, Senator Lee. Gentlemen, thank you for being here. We're going to keep the record open for a week. I'm sure that many of us will be submitting questions for the record. We appreciate your time, and I appreciate all the members' active engagement in this committee. The committee's adjourned.
That was fun. Thank you.
It was fun.